It's right here. You know that?
She has the intern for him.
Okay. Who is it?
Oh, Judge Simpson.
Oh, it's Judge Simpson?
Yes, sir.
Oh, okay. Welcome there, sir. Okay. Okay. What I want to have you do is it's going to be a walk. Hold on. Hold on, sorry, wait, wait. You stay right there for me. Hey, how's it going? This is going to be a short for you. Yeah. Just so you ran through the length of the word. Yeah, it's fine. Oh, I'm just double checking to make sure that she's okay to drive. Yeah.
Like, scared because I didn't know his name was
Target.
What you just saw is police cruiser dashcam from the night of September 8th, 2013. Krista Vargas just crashed her Mercedes into a tow truck. The first person she calls is her law professor and boss, Judge Cedric Simpson. Within minutes, Judge Simpson shows up at the scene. Under oath, this is how Judge Simpson described that moment.
The officer and I were walking down that way, and I was looking at the vehicle, and I was shocked that it had survived a tow truck.
What vehicle?
Hers.
And what kind of a vehicle is it, sir?
I'm not an expert on pulling cars, so it's a small, boring.
Isn't it a Mercedes?
It may be a Mercedes. Yeah,
Okay.
I'll take your word.
Now, when an officer says, I'm just trying to make sure she's okay to drive, what does that mean to you, sir?
It could mean a number of different things.
An alcohol investigation is one of them, isn't it?
It could mean that.
And in response to that, you offered to give her a ride, correct?
Well, I said, what did she need a ride? She needed a ride or something.
And if the answer would have been yes, where were you going to drive her to, sir?
I don't know.
Were you going to take her home?
I might have. I don't know.
Who's home? And where does she live?
At that time, I would not have known. I would have had to probably get direction from her.
By the way, did you have the officer's permission to approach Ms. Vargas at that point?
What do you mean that I don't?
Well, you start walking towards where Ms. Vargas is, don't you?
Yeah, well, we both do, man. If you look at the tape, he's like talking to me, and we both sort of turned. I don't know that I asked for any express permission. Certainly, if the officer had not wished me to go that way, he would have said so. And there's not a doubt in my mind.
You think he would have told you, get out of here, correct?
Oh, absolutely.
If that were where Judge Simpson stopped, chances are good he wouldn't have faced the Judicial Tenure Commission. The next morning, Judge Simpson called the Pittsfield Township prosecutor. He questioned the evidence and described Vargas as a good kid in a bad relationship. He may have also tried to pull some strings. That phone call turned his questionable appearance at his intern's arrest into the inquisition. Vargas posted this after the pendency of his case.
Just to point out some clarifications, I did not have a relationship with Judge Simpson. I told this to the Judicial Tenure Commission, which I'm going to refer to as the JTC, and they obviously have consistently ignored the fact that I told them that. However, that is not out there in the public because they didn't want it out there. Also, just another clarification, I really don't like to say this, but I've come to realize that I am a domestic violence survivor. So it's another reason why I'm making this video, so that people that went through what I went through do not consume in that fear to take a stand and talk to someone, because it can make a difference in their lives the way it made a difference in mine. Eventually I met Judge Simpson, and at school he was my professor. He was very different from the law professors I knew. I mean, most of the professors were very friendly. Judge Simpson expressed compassion and interest in his students' well-being, along with like building this internal strength in his students and treating us like peers. He taught us about, you know, listening with an open ear and an open heart, not just black and white law, because the law is complicated. He was our mentor. To me, he was a father-like figure. And I say this with full respect and nothing more, nothing less. Judge Simpson built this internal strength I had previously lost as a result of being in this ugly relationship with Matt. My anxiety drastically eased just knowing that there was someone out there, the judge, I mean, other than the dean, that generally cared about students' well-being and success. And a lot of you that know how he is, you know he's fair. You know he's humble. You know he's very empathetic. And he will take time to listen. That's what he taught us. Eventually, this famous Nassif case that you guys are aware of was handed to me by Judge Simpson. And this was an Ann Arbor attorney accused of criminal sexual conduct and narcotics. It took me a lot of research. Had to go over 100,000 or more text messages that the police obtained from Nassif's phone at the scene. So the judge and I had to go over that together. The communication between the judge and I was obviously frequent, and I disclosed that to the JTC. I didn't deny that. This is a communication that I chose because it's faster, it's more direct, it's an easy way of portraying information versus being on the phone all the time. And to get to the point, yes, the judge did come to the accident, but he kept a distance. And you've only seen part of the video of the scene and not entirely. So I think it's important that, you know, the public requests to see the entire video because it's obvious he kept his distance.
After hearing from several witnesses, including Simpson and Vargas, the Judicial Tenure Commission voted to recommend removal of Judge Simpson from the bench. They took their argument to the Michigan Supreme Court on October 6, 2016.
I think it strains credulity to believe that anyone who is a judge and who appears on an active scene of a post-accident event and introduces himself as a judge and is then permitted to talk to somebody who has been arrested and sitting in the back of a police car has not interrupted the normal procedure. I think that's a very tough argument.
Mr. Mogill, I would like to hear more about the third point that you're talking about, which is explaining to us the justification for some 15,000 contacts by phone, text, or telephone over a few months period of time, and how that somehow has something to do with reviewing documents for a case. I worked on cases and I reviewed thousands of documents myself in my legal career, and I don't remember texting the partner that I was working for or calling during all hours of the day and night. I'm not sure how. It just doesn't make any sense to me, and I'd like to hear you tell me why it should.
It's quite clear that there was some kind of emotional relationship that would prompt 15,000 kinds of communications, a level of intensity that might explain why he showed up that morning and why he was so interested in talking to the prosecutor. That and it's trying to gloss over that motivation that I think is the biggest problem for your client. That your client does not appear to have been candid in making those explanations. To address the thread of those cases I cited.
Yes.
Is that when a judge lies under oath, it makes it hard for that same individual to turn to somebody else and expect them to tell the truth when under oath. if, as the JTC has found, that he lied under oath, how is it that isn't a fatal act? Why doesn't that alone require that the judge be removed from the bench? I understand there are a lot of transgressions that a judge can do that are not fatal. They're mitigating. There's a long service here, honorable service in the community. But there's some things that we are held as judges to that are cardinal. And telling the truth is something we expect of everybody when they're under oath, of course, as judges.
I believe that all those innuendos not only implicate the conclusions in count 3, but they cast the allegations in count 1 and 2 in a very much different light, too.
The Commission's determination was that respondent had breached numerous standards of judicial conduct, and it recommended removal plus cost, and that recommendation should be adopted by this court. Respondent is not charged with a relationship. The relationship is what puts his actions in context. It provides a motive and intent for his appearance at the scene. There were 6 text messages between 4/20/09 and 4/23. The communications are important because they show up some kind of a motive for respondent to have appeared on the scene. Respondent from the inception argued that he had absolutely no relationship with Ms. Vargas, that it was only professional relationship, and he only responded to the scene out of some concern. As the investigation was proceeding, it became clear that this relationship is far more than that of a mentor and a student. That relationship
Why do we care about that?
It's not that we care about the nature of the relationship. What we care about is the misrepresentations that respondent had started making with the comment letter. In fact, he never mentioned having any context with Ms. Vargas. In the 28-day letter, he never mentioned having any context.
I guess the question is, why is this all relevant?
Because it provides motive for his actions on September 8th, 2013. Yes.
So what if he had just shown up, she's his intern, that's all. And he shows up at the scene, it'd still be interference or it wouldn't be interference. Why does it matter what his relationship is with her? It's interference or it's not interference?
Showing up at the scene of an accident in your own jurisdiction is misconduct.
Okay, but why does it matter whether he's showing up because he's having an inappropriate relationship with her or because he's having a completely appropriate relationship with her?
Because he has made misrepresentations as to that, the nature of that relationship.
Yes, so why do you care why he showed up?
Like I said before, because it provides a motive for his appearance at the scene, and it provides his conduct that puts it in context.
You said that showing up at the scene is misconduct, period. It doesn't matter if it's for good reasons or bad reasons.
Exactly.
If my kid is in an accident and it's 4 a.m, apparently I should not show up in Ann Arbor because I will be committing misconduct.
If you showed up at the scene of your child's car accident and you introduced yourself as Justice McCormick and you interrupted sobriety test and then you contacted the prosecutor's office, it would still, yes, be inappropriate.
If he says, look, I have a relationship, I'm concerned about this young lady, and that's why I came. And that's why I was pressing with the prosecutor. I know it was wrong, I shouldn't have done it. But, that's one level of misconduct.
Correct.
You shouldn't interfere with a field sobriety accident test. You shouldn't intrude as a judge and you shouldn't call the prosecutor and sort of chat him up. Okay. But I'm trying to figure out how all these communications become material to the misconduct.
Because he made misrepresentations about those contexts.
So let me ask this question. I think this is something that Chief Justice Young and Justice Markman got at. In standard perjury law and standard false statement law, you have to make a statement, has to be false, you have to know that it's false, and the statement has to be material or relevant. So if you had put a judge under oath and you asked him, have you ever cheated on your wife? And he's been married for 50 years, but in fact, 6 months after their wedding, he had an indiscretion. And he doesn't want to reveal that. And so he says no. But that question, whether he's ever cheated on his wife, has nothing to do with the investigation at all. Do you read our case law to say that his lie, which is a lie, means that he must be removed from office because it's a lie under oath, but not because it's a material misstatement under oath. So you don't think there's a materiality requirement?
No. The most critical lie in this was purpose for his appearance on the scene, the purpose for contacting the prosecutor.
Okay. What did he say his motivation for contacting the prosecutor was, and why was that a lie, and why was it material?
The purpose for contacting the prosecutor, he indicated, was to confirm her story, to verify the breathalyzer, and to determine whether he wants to keep her as an intern and not to interfere with the prosecution. All of those were lies. The
So
purpose
they're lies because we can know for sure that his motivation was other than he thought it was. You're saying that what he said about his own motivation is a lie. This feels a little hard. It's not like he said, if he said, I didn't call the prosecutor, never happened, didn't happen. Easy case, that's not true. We know he called the prosecutor, right? But what you're saying he lied about is why he called the prosecutor. And you might be right, because maybe, we're all human beings. We have complicated, things that motivate us, right? The world, people are complicated. But we have to determine that he lied about his motivation, and that is the same kind of lie that we have held in other cases is sufficient to remove someone from office. You see what I'm saying? This is like a complicated way to say this is a job-ending lie when it's about someone's motivations instead of, I didn't call the prosecutor, didn't happen.
In a July 25, 2017 opinion by Justice Viviano, joined by Justices McCormick, Bernstein, and Larson, the Supreme Court held the JTC correctly found that respondent committed judicial misconduct, but it erred by concluding that removal from office was warranted. Respondent engaged in conduct involving intentional misrepresentations or misleading statements. A suspension of 9 months without pay was proportional to the misconduct. Judge Simpson paid costs of $7,500 and served his suspension, which ended April 25, 2018. Other than this case, Judge Simpson has no other discipline noted in the public record. If you're still here, thank you. Let me know in the comments if you're surprised to learn this about Judge Simpson, whether you think he got off easy or anything else.